All right, I have noon Mountain Time. Good afternoon, everyone, or if you're here from the Pacific Time Zone, good morning. My name is Jay DeVoy. I'm an attorney and of counsel with the law firm of Holland Hart. I'm here to speak with you today about some updates that have been happening at the state level with respect to COVID-19. Excuse me, with respect to COVID-19 immunity and the changes that have happened, some of which have been in progress with executive orders and emergency declarations, and some legislative changes that have happened as well during that time. And this is my information. What we're going to be doing is going through a presentation. I've covered a number of states that comprise the Mountain West, namely Idaho, Wyoming, Utah, Colorado, and Nevada, talking about some of the changes that have happened there and just reviewing that. And if you have any specific questions, there's a question and answer box in the lower right corner of your screen. Please feel free to ask questions there. I will respond to any questions that are presented at the end. If there are any questions that are not covered today, or if there is a subject that is something that might be perhaps too particularized or too sensitive to put in the question and answer session, please email the organizer of today's webinar. Individualized responses will be sent to those questions in order to respond to the issues that are addressed today. As a disclaimer, this is a general presentation. This is not legal advice. If you have a specific legal question, please reach out to the firm and we can address that separately. This is just general information and does not necessarily reflect the views of Holland Hart LLP, just me personally as the presenter giving this information to you. What we're going to be talking today concerns the immunity that is available for COVID-19 across a number of different states. This is in reaction to the state of emergency that it was declared at the federal level and then resulted in states of emergency being declared at the individual state levels, triggering those state emergency response laws and allowing the states to cooperate with the federal government under the Stafford Act. And as part of that cooperation, providing protections and immunities to individual businesses and specifically to healthcare providers and or healthcare facilities. There are two primary sources of this protection. The first is with executive orders and emergency directives, normally given by the governor, either within the normal course of the governor's operations or pursuant to the emergency laws that were enacted after the declaration of a statewide state of emergency. The rationale, as you'll see in the laws that we're going to discuss, is that because viri and bacteria are naturally occurring, a pandemic falls under the category of a natural disaster and can be subject to state and federal laws regarding the same. Another source of protection regarding COVID-19 that takes longer to implement is legislation. Depending on the particularities of each state, when its legislature meets, and the protocol for getting the legislature to meet quickly and enact legislation that can be passed to the governor for immediate action, some states have acted on COVID-19 legislatively as early as 2020, while other states have a more delayed response. Of the states we're going to be discussing today, all of them have acted during the course of 2020, but some had to call special sessions to do so, and some of them have provisions that will need to be revisited this year as the pandemic continues to wear on. Other key distinctions we'll be talking about are that medical providers are in some states treated differently than other businesses, and in certain states, medical providers might have been covered in the first round of executive orders and emergency declarations, but the legislation tends to have been more deliberate in terms of expanding those protections and immunities and sometimes conditioning them and qualifying them for businesses that don't have a medical character or medical facilities as well. So to understand the history of COVID, we need to go back to the very beginning of it. We recently celebrated a birthday. On January 31st, 2020, the United States Department of Health and Human Services declared a public health emergency with respect to COVID-19. That was followed a little bit more than a month later on March 13th, 2020, with President Trump announcing a national state of emergency under two separate acts. First was the National Emergency Act, which made federal resources, funding, and facilities available for responding to the coronavirus. And then the Stafford Act. The Stafford Act is a more recent law that was passed in the late 1980s, which exists to facilitate disaster and emergency response between the federal government and the states, and to make funding and resources available to the states in their emergency response efforts. Around that time, in some cases shortly thereafter, generally after the public health emergency had been declared, but before or contemporaneous with the presidential declaration of emergency under the National Emergency Act and the Stafford Act, individual states began declaring their own states of emergency. And in some states, depending on how the different administrations, divisions, and agencies operated, some of them had separate declarations of public health emergencies and then statewide states of emergency. Of the states that we've looked at, Utah was the first, initially declaring its state of emergency on March 6, 2020. That state of emergency has been periodically renewed and modified. So if you went to look for these documents online for Utah, there would be a number of expired documents, but the lineage of the state of emergency in Utah related to COVID-19 traces itself back to March 6 of 2020. Other states that declared emergencies in relation to COVID-19 were Colorado and New Mexico on March 11th. Nevada declared its state of emergency on March 12th. And on March 13th, Idaho and Wyoming joined in. In most cases, these orders were swiftly followed with stay-at-home orders that closed non-essential businesses, the general thrust of which being businesses that weren't grocery stores or providing medical services and other key functions such as utilities generally were closed within these states on a statewide basis. The nuances of what was considered an essential versus non-essential business differed a little bit from state to state, but the general thrust is that anybody that was not necessary to keep society functioning and help with its emergency response was ordered to go home and to find a way to work from home if possible. As imagined, this caused a great degree of economic dislocation that we're still dealing with today. The ability of the states to respond to these emergencies is generally defined within their emergency powers. As we'll see from these examples, some of the state privileges and immunities for emergency response look similar, but generally each state has its own body of laws that have to do with emergency response. Now, these laws and the extent of them have not been tested in the modern era. What's significant about these laws is that the last time there was this kind of long-ranging emergency that went on was probably in World War II. And the last time that issue came up in front of the United States Supreme Court, it resulted in a number of decisions, including Korematsu versus United States, in which the United States Supreme Court famously upheld the internment of Japanese American citizens during wartime. Today, everyone recognizes that decision was badly made and was wrongly decided. And even during their Supreme Court confirmation hearings, the recent justices who have been asked about it have all agreed that it was an embarrassing and shameful decision that was rendered by the Supreme Court. But that gives context only for the purpose of showing how long it has been and how much has changed since the last time that there was any meaningful legal challenge to these emergency powers, and how much the priorities and how much the law has shifted in this area as well as society. So for that result, there have been a number of legal challenges mounted to date since the beginning of COVID, and even during that time frame, a number of decisions have changed on that basis, even addressing similar issues. Nevada was at the forefront with one of the first decisions that made its way up to the United States Supreme Court, which had to do with the challenge to the emergency orders that closed churches, with the petitioners trying to reopen churches on First Amendment grounds, arguing that there was a discrimination against religion and a deprivation of the right to participate in religious ceremonies. And that closure from the state of Nevada was originally upheld. Now, with time, there have been more recent decisions, I believe the most recent of which affected California and effectively revised the state's stay-at-home order so that religious facilities and religious institutions could only be restricted as much as the most restricted secular operations, such as a restaurant or some other kind of facility. So the idea here wasn't to draw equivalencies between the function of a religious organization and a non-religious secular organization, but to show that there was no basis for restricting a religious institution more than another one and allowing them to reopen, consistent with the other most restrictive provisions with the state's reopening order. And I anticipate there'll be more litigation on that, although my impression is that the U.S. Supreme Court is reticent to get involved in what they likely view as a state matter and something that is an issue of really political determination by the people within that state. But turning to the state's emergency powers, in order to even invoke those powers and receive the benefit of them, the state must first have a declared state of emergency, which opens the gate to using these powers to their fullest extent. Looking to Nevada as an example, the powers and the duties reserved to the governor during an emergency are defined in NRS 414.060, and it explains that the governor, and with the emphasized text in this slide, can have direct operational control over all or any part of the functions of emergency management within the state. And that basically gives the governor or his designees and functionaries the ability to take over any part of the emergency response, whether it be for medical, provision of supplies, or taking over any other part of the state that needs to be operational to ensure that the state continues operations, such as through delivery of power, utilities, and obtaining any resources necessary to do so. The powers that the governor has are also specifically defined within Section 3, Subpart A, where it says that the governor has the ability to make, amend, and rescind the necessary orders and regulations to carry out the provisions of this chapter within the limits of the authority conferred upon the governor within the chapter. That's a little circular, but the premise of it is that it gives the governor the ability to make these executive orders and these emergency orders that Nevada has that set policy on an ongoing basis, and these orders are set to either expire or are terminated by the governor to set what the priorities and what the actions of the state will be in response to emergencies, including coronavirus. We'll discuss in a bit some of these orders that the state of Nevada has issued. A number of them include, for sake of reference, moratoriums on evictions, stay-at-home orders, partial business closures, and dictating what the statewide standards will be for reopening and the agencies that are responsible for enforcing them and putting them into place. Other states have similar provisions. Colorado stood out as being somewhat extreme in its own regard. It's very similar to Nevada. The Colorado statute found at Colorado Revised Statute Section 24-33.5-704 specifies that the governor is fundamentally responsible for addressing the needs and meeting the dangers of the state, and it gives the governor the ability to issue executive orders, proclamations, and regulations that have the force of law, which is significant because normally laws can only be made by the legislature, and this provision elides that power into the governor's office during the times of emergency, where effectively the governor's word is law. To contemplate the extreme powers that are potentially available under Colorado law to the governor, Section 6 of this statute stood out in particular, saying that the governor is the commander-in-chief of the organized and unorganized militia and of all other forces available for emergency duty. So it contemplates very broad, wide-reaching, and even quasi-militaristic power for the governor in responding to emergencies within the state of Colorado. One of the main benefits of an emergency being declared and being able to proceed under the state's emergency response powers is the fact that those actions are immune or conditionally and qualified to have immunity from certain types of liability. Normally, the state, any state, would have a partial waiver of sovereign immunity. Sovereign immunity is the concept that you can't sue the sovereign. You know, the state owns property, the state provides these services, and in exchange for doing so, it limits the right of the individuals to sue the state and the damages that could be recovered from bringing such a lawsuit. In Nevada, for example, if I were to get into an accident with a police officer and it was the police officer's fault, the sovereign immunity statute, which I believe is potentially going to be amended, but the last time I looked at it, would allow for me to have a maximum recovery of $100,000, no matter how significant or minimal my injuries would be from that incident. So sovereign immunity normally exists as a partial concession that the state could sometimes be liable to individuals for state-based claims. Without getting too far afield, there's an exception for federal claims, which is how these civil rights claims that come up from time to time can have values that far exceed what the sovereign immunity cap is within a specific state. But generally, states jealously guard their ability to be sued by citizens and be liable to citizens under state law. And these protections are ramped up under the emergency power statutes that are present in Nevada and in other states. The statute that's on the screen right now has to do with Nevada's immunity during times of emergency. And it dispenses with the idea of any kind of waiver of sovereign immunity. And it specifies that neither the state nor any political subdivision of the state or agencies of the state or any people who are acting on behalf of the state will be liable for any injury or death except in cases of willful misconduct, gross negligence, or bad faith. So unless there's incomprehensibly negligent conduct such that anybody would figure out that there was a problem with it, or it was willfully directed at somebody, the state and its actors are not liable to any person for injury, damage to property, or even death that results from their actions taken during the time of emergency response. And this is significant because the way that the state of Nevada has handled this, that we'll be discussing shortly, is that it has brought healthcare responders under the umbrella of people who are responding on behalf of the state to an emergency, and accorded to them this liability for the services that they provide in response to COVID-19. So looking at what other states have done, based on the emergency powers that are available to them under law, a variety of different states have issued orders protecting healthcare providers and in some cases facilities to varying degrees. A number of these orders are still in effect and are contemplated to last the duration of the emergency. They either need to be periodically renewed, or they last until terminated or the expiration of the state of emergency, or for a period thereafter to allow for a wind down period to make any changes that might be necessary to adapt to any kind of operations after the COVID-19 emergency. Illinois and New York were two of the first states and two of the most prominent states to issue these kind of immunity waivers or these orders granting immunity to healthcare providers and facilities. Other states didn't necessarily need to issue these kinds of orders because they either had existing legislation in place like California, or their legislature was able to act fast enough to address these issues with legislation obviating the need for administrative orders or any kind of executive action to grant immunity to healthcare providers. An example of this was Illinois Executive Order 2020-19. This was significant because it addressed facilities, healthcare providers, and volunteers. And if they were acting in the course of providing support for treatment or testing of COVID-19, then they were granted immunity. So long as they were rendering assistance, they were immune from civil liability for, quote, any injury or death that occurred at a time when engaged in the course of rendering assistance, unless the injury or death was caused by gross negligence or willful misconduct. The recurring theme of all of these protections is going to be that unless there is some kind of willful act or incredibly reckless act that can't be explained by just ordinary negligence and the exhaustion, the fog of war, so to speak, in dealing with COVID, there will be immunity available for it. This language is very similar to indemnification statutes or indemnification provisions and contracts that some of you have dealt with, and the same standards would apply. So it's useful to import that line of thinking over to dealing with these kind of protections when they exist, whether created by statute or by executive order. The next state we'll be looking at is New York. New York issued Executive Order 202.10 early on in the pandemic. It provided two important forms of relief. The first is that there was absolute immunity provided for practitioners who did not maintain records that normally would be necessary for billing or treatment purposes, or to establish that the standard of care was met and to document the care that was provided to that patient. So this was only in relation to COVID-19. The grant of immunity, although absolute, was fairly limited to record keeping that was, quote, to the extent necessary for healthcare providers to perform tasks as may be necessary to respond to the COVID-19 outbreak. This is a rare grant of absolute immunity, so it was narrowly tailored to record keeping in relation to care provided in treating COVID-19. But it's an important grant of immunity and immunizes healthcare providers, not just in New York State, but people who are licensed in other states and were providing care in New York based on what they were allowed to do. They were not penalized for not keeping records. And this contemplated a scenario where record-keeping materials or technology or information might not be available, such as to people who were being provisionally credentialed and did not have access to any kind of electronic health record software, people who were just coming in to lend in a helping hand, such as PAs from out of state who were able to travel into New York and to provide these services and wouldn't necessarily have the kind of credentials or logins necessary to maintain these electronic health records. So that absolute immunity was important to not disincentive and, where possible, incentivize and reduce the risk of individuals coming into the state to assist with COVID-19 response. Now, the scope of the order that granted immunity for any kind of injury, death, or damage that occurred while providing treatment to patients related to COVID-19 is a little bit more limited than the Illinois order. The New York order applies to physicians, physician assistants, nurse practitioners, registered nurses, and LPNs. Now, this granted an immunity that was similar to that in Illinois, where they cannot be liable for damage, injury, or death unless they acted in bad faith or engaged in willful misconduct or grossly negligent in providing their services. But otherwise, the grant of immunity is fairly similar, just a little bit more narrow in terms of who it applies to, inuring for the benefit of individuals rather than facilities. Turning to Nevada's emergency directive, it was issued in April of 2020 and is still in effect. The definition of providers that it applies to is exceedingly broad. It applies to virtually every licensed person in or relating to the medical profession, including professionals in behavioral and mental health, such as social workers, psychologists, and counselors. It also prominently allows for practice outside of the scope of licensure, but within the scope of competency. So if an NP or a PA was familiar with a specific specialty in medicine, such as neurology, or they had an orthotics background, or they did a lot of work in psychiatry, they were competent to do things that might be outside the scope of their practice, such as for a PA, acting based on their knowledge without direct physician supervision, but only based on their competency. So there's a limitation where the state decided that this would be an allowable trade-off as long as people were restricted to, number one, the immunity only for providing services in connection with COVID-19, and number two, only acting within what they knew, not empowering people to exceed their licensure and try new things or discover new areas of medicine to provide services to individuals. The most significant section of this emergency directive for healthcare providers was Section 10. It reads, all providers of medical services, which, as an aside, were defined in Section 1 as broadly construed, related to COVID-19 are performing services for emergency management subject to the order or control of and at the request of the state government, and shall be afforded the immunities and protections set forth in NRS 414.110, subject to the same exclusions. So the statute we were just looking at and just describing that had no waiver of sovereign immunity did allow for claims to be brought in the case of willful misconduct and gross negligence or bad faith, but generally, for people acting in the ordinary course, even if they had regular negligence, do not have liability as part of the emergency response of the state of Nevada in treating COVID-19. Now, this isn't talismanic or blanket immunity. This doesn't apply to unrelated claims, such as surgical errors that occasionally happen where the wrong limb or the wrong extremity is operated on or subject to the procedure. Those rights would be unimpaired for somebody who was injured. But in terms of providing services and care and connection or related to COVID-19, however that ends up being defined, there is an immunity in place as long as the person does not act with gross negligence or in a willfully wrongful manner. Now, that's an overview of what has been done at the administrative and the executive level through state agencies and through executive action. The corollary to this is state laws, which are created by the legislature and signed into law by the governor. Generally, but not always, these have been slower to come about than executive action just because the process for creating them is fundamentally different and slower. Going back to Schoolhouse Rock, which I hope some people on the call do remember, there's the old song about a bill becoming a law, having to go through two houses of the legislature and then be signed by the executive. In the Schoolhouse Rock example, the president, but at the state level, generally the governor. And then the exceptions that exist for if something is vetoed, it can be approved and the veto overridden within the legislature. I don't think we have to contemplate all of those things today, but there are some interesting scenarios as the COVID-19 response becomes more politicized and more partisan in nature, that some scenarios that might have seemed unthinkable and likely seem unseemly to many in responding to a national health emergency may become realistic scenarios in the near future. So while emergency directives and orders can have the force of law, they do expire when the state of emergency ends, and based on the law of the state, they can have automatic expirations built into them and have to be periodically renewed. And in some states, the state legislature has the power to override the executive and state that the state of emergency is ended or it's not validly being continued. Those vary from state to state. I'm not familiar of any scenarios where the legislature and the executive are at such contretemps that that's seriously being contemplated, but in certain states that is an option based on their emergency response laws. Part of the reasons for delayed legislative responses arise from just the nature in which the legislature works. Statutory requirements control when a legislature can be called into session. For example, in Nevada, the legislature meets for 120 days every other year. Any other session of the legislature needs to be called in as a special session that can be called by the governor or a specific percentage of the legislation. So what happened in 2020 is there were two special sessions of the legislature that were called by the governor that dealt with two issues that were related to COVID-19. The first had to do with the financial part of it, which had to do with some cuts to Medicaid and other state funding, parts of which are being restored now during the regularly scheduled legislative session in the state of Nevada. And then the second session had to do with business immunity and other issues related to COVID-19, one of which we'll discuss a little bit later in this presentation. Other reasons why the legislature takes longer is because it's designed for in-person proceedings. Some of these legislatures likely only contemplate or allow for proceedings to happen in person and might have needed changes to rules or procedures or regulations in order to allow for remote meetings that became so popular during the current pandemic. I know that the current legislative session in the state of Nevada is proceeding largely through Zoom or through other automated means and not in person, although there is still some activity at the Capitol. This has made the session progress slower. It has made interaction and participation by third parties harder. But most importantly, depending on the state and what the procedures are and if they ever contemplated something like this, the mechanism may not have been in place when this arose to even allow the legislature to lawfully gather, assemble, debate, and pass legislation for the governor to consider. So as a threshold issue, that had to be evaluated and in some cases remedied by different state legislatures. Additionally, the job of the legislature is to get feedback from stakeholders to determine what's feasible and then what legislation had to be drafted, normally by coordinating with an office that prepares the drafts of legislation due to the familiarity with that office's familiarity with other bodies of law that have been passed within that state, so that it understands when you make a change to one area of the law, it might implicate others. And as we'll discuss in a moment, in a number of states, there are already immunities that were put in place that could be affected, limited, or constrained or compounded by the immunity that was granted by COVID-19. And then the other issue that was briefly discussed earlier was that legislatures generally are bicameral and have to work in tandem with the executive. In certain states, there are situations where one house of the legislature might be controlled by one political party versus another. And then in other situations where the legislature is controlled by one political party, yet the executive branch is controlled by another. For example, in Pennsylvania, the legislature is controlled by the Republicans, yet the governor is a Democrat. They've still had a response to COVID, but that consideration and the interplay between the two political parties that have increasingly adopted different and mutually exclusive views for the response to COVID-19 can make it difficult to have an effective, timely response to coronavirus. So that is another reason why there was a potential legislative delay in responding to coronavirus, just due to the horse trading inherent to state politics. Now, to the point about affecting existing laws, a number of states have existing protections for Good Samaritans who provide gratuitous emergency care, whether at the site of an emergency or otherwise. In some cases, this extends to emergency services to assist in childbirth or emergency supervision of other people, such as physician assistants or nurse practitioners that are responding to an emergency at the scene of the emergency. Some of these examples exist within Nevada. And another example that exists among many states in one form or another is the immunity that exists for volunteers who, for no compensation, provide services to nonprofit entities. Many states and many areas have free medical clinics where medical providers can provide their services. And in the course of providing that volunteer service in exchange for no compensation, they are provided a number of immunities under state law and sometimes under federal law, depending on whether or not that clinic qualifies for immunity under the Federal Tort Claims Act under some revisions that were made within the last 2 decades under the public health safety laws. So that is another consideration that comes into play. And in the course of the legislature trying to fashion this immunity, it had to be mindful of these other immunities that already exist and strike a balance that does not limit those immunities or reflects the fact that some of these scenarios that are being proposed might have unintended consequences by expanding upon the immunities that were previously deliberated by the legislature and passed. Looking to a couple of specific examples within the Mountain West, Utah had a fairly prompt response to COVID-19 in April of 2020 and passed SB 3007. The operative provision is that a person is immune from civil liability for damages or an injury resulting from exposure of an individual to COVID-19 on the premises owned or operated by the person or during an activity managed by the person. Now, of course, this isn't restricted to natural persons. This is a legal definition of person that includes individuals as well as entities that have the same function as personhood, such as a company or a corporation or a trust or some other kind of business entity. Now, the immunity that's granted by this law is not limitless. It doesn't apply to willful misconduct. It doesn't apply to the reckless infliction of harm or the intentional infliction of harm. Additionally, this area of law does not affect the laws. This new statute does not affect the area of laws regarding workers' compensation, occupational diseases. This is an interesting untested area that I'm sure we'll be seeing some more law with in the near future, just because workers' compensation law generally covers illnesses that somebody contracts in the workplace. So it'll be interesting to see if there's any kind of changes to insurance premiums, if there's any kind of relief coming from state insurance commissioners, or if the workers' comp insurance companies are just going to have to deal with this on a case-by-case basis and duking it out and getting into a fight with claimants about causality and whether there's a proximate or legal cause to the illness that the person claimed to have incurred during the workplace. Speaking to my observations in Nevada, I don't practice in this area, but I am familiar with workers' comp insurers and the concerns that they have, and they are frequently stuck with claims such as building sickness, mold claims that can come up from time to time, and those fall under, again, speaking for Nevada, Nevada's occupational disease statutes and are covered by workers' comp insurance. So there is a window where workers' comp insurance could end up covering some of these claims, but different states have dealt with it differently, and it is something that is going to take some time and some claims to bear out to see, even if not a final answer from the state Supreme Court or a final determination by the state's legislature, at least preliminarily, how courts or the administrative bodies that decide these workers' comp claims are evaluating them as they're brought. Similarly, Wyoming enacted a statute in May 20 of 2020. During a declared public health emergency, it provided, quote, any healthcare provider or other person, including a business entity, who in good faith follows the instructions of a state, city, town, or county health officer, or who acts in good faith in responding to the public health emergency, is immune from any liability arising from complying with those instructions or acting in good faith. So this specifically calls out healthcare providers as individuals and includes business entities and does not specifically exclude any group or entity from its protections. So the reading of the Wyoming statute allows for healthcare facilities to be covered by this as long as they are acting in good faith by responding to the public health emergency and acting as directed by the county. So this isn't talismanic immunity. If there are ordinances that are promulgated at the state level or the closer municipal level about how, for example, a surgery center is supposed to govern itself and maintain standards of cleanliness during this time, and the surgery center decides not to comply with those standards, then it will not be eligible for this immunity. But as long as these companies act in good faith to comply, they're eligible for immunity, as are individuals that are healthcare providers within that state. Now, notably, Wyoming incorporated some of the protections that we discussed earlier within the Nevada Emergency Directive 11 about practitioners being protected from liability and able to provide services under circumstances when they normally couldn't. Specifically, the Wyoming statute allows for healthcare providers who are retired or have inactive licenses or are licensed in states other than Wyoming to practice medicine in Wyoming and receive the benefit of this statute in return for the care they provide to patients. And as we've seen in other states, immunity does not apply to acts or omissions constituting gross negligence or willful or wanton misconduct. So again, when treating COVID patients, this immunity is not an absolute shield. It serves to protect providers who are providing legitimate services, but does not act to shield individuals who are acting in bad faith or not acting in a way that is even in the same universe as the applicable standard of care. Idaho passed House Bill number 6, which was codified in the Idaho Code as a new chapter under Title 6 of the Idaho Code, and it's sections 6-3401 through 6-3403. It was passed in August of 2020 during the first extraordinary session of the Ohio legislature. And it's a fairly short bill that was passed. The operative portion of the grant of immunity reads, quote, a person is immune from civil liability for damages or an injury resulting from exposure of an individual to coronavirus. And as noted in the slide, Person, like the other statutes, is very broadly defined to contain a large degree of business entities that could have legal personhood under Idaho law. Now, like the others, Idaho's immunity does not extend to conduct that constitutes an intentional tort or willful or reckless misconduct. And also, like the Utah statute, does not affect workers' compensation laws, including occupational illnesses. What is unique about Idaho's law, however, is that because it created a brand new chapter of the Idaho Code, it had a provision that was built in that is part of the bill but is not part of the statute that was ultimately put on the books in the Idaho Code, is that the law sunsets on July 1st, 2021. Given that we are now going into March, and while vaccine distribution seems to be making progress, there's not quite the point of herd immunity. It remains to be seen whether or not it's going to be necessary to extend this deadline and extend the immunity that is available to healthcare providers under Idaho law, and if Idaho will have met its vaccine distribution requirements at that point and effectively eradicated effectively eradicated the virus within the state, or if it will be in a point where legislators will have to make the decision to either extend by passing a mandatory legislation the protections that are available within these newly created statutes, or if it will be a policy decision where the legislature will decide, although there's still coronavirus, it's significantly reduced, and the decision is that the risk of harm or the risk of infection can be passed on to healthcare providers and other businesses. That last option seems unlikely, but there likely will be a contingent of people, possibly among them plaintiffs' attorneys, agitating for that outcome. Now, turning to Nevada, Nevada's standard is unlike the other ones that we have discussed and have seen passed in other states. During the second special session of 2020 and the 32nd ever special session of the Nevada legislature, it very quickly introduced, revised, adopted, passed, and then had signed by the governor a bill known as SB4, which made sweeping changes to Nevada law regarding the protections available to businesses in the event of patrons being exposed to coronavirus. What was significant about this law is that it set up this multi-step process that did not stop lawsuits, but made them fairly difficult to win for businesses that were acting in compliance, and contemplated a compliance regime that would be created by the state that didn't exist at the time and that the state has had to work frantically to put into place. So the way that SB4 works is that it provides qualified immunity from liability, but not liability from suit. The distinction here is that if you're immune from liability, if you prove that the immunity applies to you, you're not liable for the other person's damages. Liability from suit, however, is a liability from ever having to set foot in the courtroom beyond perhaps having to file a motion to dismiss to explain, I have immunity from even being sued, and I should not be here. So that distinction requires the companies that are potentially named in these lawsuits to show up to court and have to prove that they're not liable and they can't be held responsible for paying damages, but they can still be subjected to the costs and attendant stressors of the judicial process. However, there are a couple of important deterrents to individuals bringing these lawsuits, which acts to limit, theoretically, the number of lawsuits that will be filed based on coronavirus contraction. Specifically, the lawsuit has to be, quote, pled with particularity. Now, there's some indication in the legislative record that people were unclear with what this meant, but to anybody who has any litigation experience or remembers civil procedure from law school, it's a fairly straightforward standard. When something is pled with particularity, that means it's subject to a heightened pleading standard and has to identify who, what, where, when, why, how, and set out specific dates, representations, actions, transactions that constitute what's normally an instance of fraud or mistake or misrepresentation. These are generally codified in the rules of civil procedure. Nevada's rules of civil procedure closely track the federal rules, and both of them specify this pleading standard within Rule 9b. So that's a first step to avoid these drive-by lawsuits where normally you could just give somebody notice of something saying, I was at this place at this date or at this approximate time, and I contracted coronavirus, and this change allows that kind of lazy pleading to be dismissed out of hand. What is required now to bring a lawsuit about coronavirus exposure and the damages for it is that there has to be a particular pleading as to what the business did that was not in substantial compliance with applicable law, how and why they were not compliant, and how it caused damage, and they were the cause of a case of contracting coronavirus. So while it is possible that someone could come to court with a properly pled complaint saying, I was at, for example, this restaurant on this day, I saw someone sneezing, they weren't at home, it was the only place I went to that week, and then this happened on a Monday at this time, I spoke to the manager about it, and then I came home, and I hadn't gone anyplace else, and 2 days later, I started feeling ill, and I got my nose swabbed, and I had coronavirus. Now, if that happened and there were damages that could be recovered from that, that would be allowed to go forward. And I don't think anybody would have any problem with that, and that was the balance that the legislature decided to strike rather than granting complete blanket immunity. So while it is theoretically possible to be sued and be held liable, it's a difficult case to do, and it was done in that way to discourage lawsuits that would harm small businesses in particular, where the cost of defending even a few actions would quickly drive it out of profitability and possibly out of business. So the standard for liability in Nevada is that a business must be in substantial compliance with controlling health standards. So long as the company is in substantial compliance, not perfect compliance, not even material compliance, but substantial compliance with the health standards that are promulgated by the government and publicized on its websites, then it is not liable. The burden is on the plaintiff to allege, meaning they go to court and can plausibly say that these things occurred, and then ultimately prove that the business didn't just violate controlling health standards and wasn't just out of substantial compliance, but violated controlling health standards with gross negligence, which obviously would be satisfied by willful misconduct as well, but with gross negligence, it's not just that somebody forgot to wipe down a table on one occasion. It has to be severe, it has to be systematic, and it has to be repeated in nature to constitute that kind of gross negligence, and an utter failure and breakdown in systems necessary to vitiate the kind of immunity that's created under Nevada law. Additionally, the plaintiff has to plead and prove that the gross negligence that violated the community health standards was also the proximate cause of the person's injury or death related to COVID. So going back to my original example, for somebody who went one place in a week, and that was the only place they went, and then they got it, they would still have a challenge of proving through medical or other records that the cause of their coronavirus was going to this one restaurant. But for many people, if they're going to one place, they're going to several places, and it is more likely that they will have accumulated a number of interactions with other places where they could have potentially contracted the virus that can't be ruled out. It would make proving factual causation fairly difficult, and which would be necessary to show legal causation and to hold the business responsible for the injury or death that arose from the coronavirus exposure. Also significant, and is something that leaves jurisdiction to the courts, where Nevada has an elected judiciary up and down its judicial system, from its district courts to its Intermediate Court of Appeals to its Nevada Supreme Court. And that distinction is that courts decide as a matter of law whether a business complied with controlling health standards. The plaintiff has the obligation of showing that the business was not in substantial compliance, but the court decides this is a matter of law. And as a result, these legal determinations are reviewable on appeal. Factual determinations are very rarely unsettled. Only in extreme cases where generally there was some kind of legal error or the jury just completely got it wrong will a court on appeal reverse a factual determination. However, where there's a legal determination and the court decides whether or not substantial compliance was present, it lends itself to a de novo standard of review, where on appeal, the Nevada Supreme Court or Court of Appeals will look at the entire record and decide, based on all of the facts in front of it, all of the inferences that can be drawn in front of it, whether or not the district court got it right. So to that end, there's some discretion that's given to the district court on that basis, and it's also going to be reviewable, and there likely will not be a final determination on this until several years after all the litigation, such as it is or will be, is filed in Nevada as a result of the coronavirus incidents. And even then, it will be subject to interpretation by the courts as to what the standard is, what will constitute substantial compliance with these health standards. And because it's determined as a matter of law, the Nevada Supreme Court may well be looking to other states and determining how those courts have examined this moment and how those courts have determined whether or not immunity applies and whether somebody has been substantially compliant with that law, or if they're violating the controlling health standards with gross negligence. And when it comes to coronavirus, what gross negligence looks like, and whether gross negligence in relation to this virus versus the normal standard of gross negligence needs to necessarily be changed or evaluated differently. So the SB4 did provide a definition of what constitutes substantial compliance, and within the statute, there is an allowance for isolated or unforeseen events of noncompliance that will not cost a business its immunity as long as it is otherwise complied with controlling health standards, which could be evidenced such as through policies and procedures. And that's all contemplated within the statute itself and contemplated within SB4. So the fact that there was a 1 or even a 2-off occurrence that was not compliant, that's not great, but it isn't going to undo the compliant nature and the compliance-based activities that are being undertaken by the business that is trying to avail itself of these protections. So there's that benefit as well, which also makes it a little bit harder to pierce that immunity that's granted. The problem for healthcare providers is that the immunity that was granted does not apply to these specific entities that are enumerated in the slide. And this includes home health agencies, hospices, intermediate care facilities, skilled nursing facilities, hospitals, independent centers for emergency care, which significantly there are very few of those in Nevada. Sometimes people think about the small hospitals or the mini hospitals, such as you could call them, that are built for between $10 and $40 million, depending on location and the cost of land. Those, at least in Nevada, are licensed as hospitals and not as independent centers for emergency care. So hospitals in general, depending on whether they're just remote emergency departments or intended to be remote emergency departments or full hospitals with multiple departments, are not receiving the benefit of this change. And then as to all other medical facilities in the state of Nevada, such as surgery centers being a prominent example, they are not specifically excluded from this definition of entities. So a decision was made at the legislative level to decide that there are certain entities that are going to have to potentially bear this risk and other ones that are going to be protected by the rules of SB4. And it generally was a calculation that appears to have been made based on the level of human interaction and care that the legislators determined that was necessary to protect patients. And I know that different entities in Nevada have responded to this in different ways. For example, some of the hospitals in Nevada, for people to visit their loved ones, originally that was prohibited. And ever since this change began, the hospitals that I'm aware of have required patients, or rather visitors for patients, to sign waivers absolving the hospital of all liability, specifically warning the individuals that they could be exposed to coronavirus. They might even contract it. And as a result, having to sign that and accept that risk in order to be, or even be remotely close to their loved ones during their time of recovery, whether for COVID or otherwise. So this issue was actually raised by a number of stakeholders with the Nevada legislature when the bill was pending. And individual physicians raised the issue, the Nevada Healthcare Association and the Nevada Center for Assisted Living all raised these issues, especially given the situation that we are seeing now, where it comes out that it appears the number of coronavirus-related in New York State was underreported and might be a source of liability for those caretakers down the line. This issue was raised with the Nevada legislature, and unfortunately, because of the nature of the special session, the legislative history and the discussions related to these bills is not as clear as it should be at this time. But my understanding from government relations professionals that I know is that the trade-off that was articulated by the legislature was that facilities don't necessarily need to worry because all of the providers are immunized. All the providers that could give rise to this liability continue to have immunity under Emergency Directive 11, which we discussed earlier. And as a result, they thought that that provided adequate protection for these facilities because the main vector for claims against the facilities in the form of the providers were adequately protected by the executive directive, the emergency directive, which could be rescinded at any time and will eventually expire. So there remains some uncertainty about what will happen in Nevada and how this will necessarily play out over the coming years. And there also is a question as to how this will affect workers' compensation and occupational diseases, since that is not squarely addressed within the bill. And that is something that could come with time and to indicate whether this is limited or interpreted to be limited only to exposures to individual consumers or to anything that will happen to people within the workplace. But that covers the legislative response in Nevada, which is acting in tandem with the executive and emergency response. And I do not anticipate much more to be done about this during the current legislative session, just because of the heavy priority that has been placed on balancing the budget and being able to maintain services in light of the decline in revenues attributable to the fall off in tourism and the lack of conventions and related activity happening within the city. So at this time, we have about 10 minutes left. I'd like to throw the floor open to questions if there are any. If you have any questions about specific states or about specific topics that were discussed, please enter them into the question and answer app in the lower right corner of your screen. If there's a question that you believe is too technical or too specific to a specific circumstance, please email that to the organizer and we can respond to you with a response to that question. But I'd love to discuss this some more. I'd love to talk about any specific questions that anyone has and to address them for the benefit of the group. So one question that hasn't come from the group, but that has come up a fair amount in the past, is about the retroactivity of statutes. Something that became very prominent probably about 4 years ago in 2017, when the state of Nevada amended its laws regarding the enforceability of non-compete covenants. And there was a question as to whether that law change applied only to non-compete covenants that were executed from that point onward, or if it was retroactive in scope. And there actually is a fair bit of law about the retroactive application of statutes. The default answer is unless there is some change in the law that makes it retroactive now, or some other kind of declaration that this was intended to be retroactive, such as a provision in the statute saying it's meant to apply beginning on a certain date, the law won't be retroactive. It's generally incumbent on the legislature to specify if the law is going to be retroactive. It's generally disfavored by courts because the issue is that if there's going to be some kind of reaching back in time to retroactively affect someone's rights, it's a pretty significant change. It's something that they are hesitant to enforce unless the legislature specifically allows it or contemplates it, which is something that is the role of the legislature versus the courts and their calculus of all of this. So to the extent that there's ever any kind of questions or debate about whether these changes would or should be retroactive, it's something that should be addressed with legislators and something that can be brought to their attention to make sure that if the intent is that these kind of changes would be retroactive, and if there is a business that unfortunately gave somebody COVID-19 and the intent of the lawmakers is to make sure that that business is not held liable, it would be better if that is explicitly stated in the legislation itself to make sure that that immunity, especially since the courts tend to jealously guard grants of immunity and narrowly construe them. The goal would be to make sure that if there is an intent to make it retroactive, that is clearly stated and that it's something that is clear and unambiguous, so the court doesn't have to confront the question about whether or not it is meant to be retroactive, since the most cautious answer and the most conservative answer, and thus one that the court would be likely to reach for fear of being seen as legislating from the bench, is that the legislation would not be retroactive. At best, there might be something in the legislative record that the court would look at and to try to define the intent of the legislature to be retroactive in nature. But the best course of action for something that is desired to be retroactive or meant to be retroactive is to explicitly state that it's retroactive, and if possible, it will be given that effect. All right, well, seeing no further questions, thank you for your time. It was a privilege to be here and to share this information with you today. If you have any follow-up questions, please, by all means, contact or email the organizer or contact me. These slides will be available after the conclusion of the presentation. I believe they will be sent to all attendees if you would like a copy of them. Again, please contact Laura Squires, the organizer, or anybody else on our team. Let us know if you have any questions, and thank you for your time and attention today. This is an interesting and always evolving topic, and there will be more developments to come, I am sure, as the executive orders change, as more legislation is passed, and as the consequences of those orders and those laws are tested in the courts and changed or challenged through other means. Thank you very much, and I appreciate your time today.